This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
All right, good morning, everybody. We're back on the record in State of Florida versus Ashley Benefield, 2020 CF 3014. I have both the state and the defense here along with Miss Benefield. Is there anything we need to talk about, state, before I bring the jury out?
No.
Mr. Taylor?
No, sir.
All right. Are you ready? Are you ready to go? Do you need another minute or are you okay?
I'm ready.
All right.
Thank you.
Now let's go and bring the jury in. All right, y'all can have a seat. Good morning, everybody. Welcome back. Before we get started, did anybody talk amongst yourselves about the case, discuss it with anyone else, or do any research about the case? Nobody says no. All right, when we were finishing up yesterday, the defense had rested its case. The state, if it wishes, can present a rebuttal case. State?
Judge, just very briefly state and call Eva Benefield.
Do solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth.
Ma'am, same rules as last time. Just make yourself comfortable. Get about 12 to 15 inches away from the microphone.
Good morning.
Good morning.
Please state your name.
Eva Benefield.
Okay. And I just have a couple of questions for you. The first is, was your dad right or left-handed?
He was right-handed.
Okay. And I just want to show you a picture. This would be Defense Exhibit 24 that's been entered into evidence of your dad appearing to do a push-up. Have you seen that before?
I have.
Okay. And when was that picture taken?
That was taken in 2018.
And then I want to show you State's Exhibit 105. Can you tell me what this is?
That's a picture of my dad on the boat.
And when was this picture taken?
That was August of 2020.
And is this an accurate reflection of the way he looked in August of 2020?
Yes, ma'am.
Okay. And Judge, I just want to publish it briefly. Oh, at this time I would enter State's Exhibit 105 into evidence.
Same objections?
No objection.
No objection received.
There. Okay. Is this the picture 105 that you just identified?
Yes, ma'am.
Okay. Thank you very much. I have no further questions.
Do you have any cross, Mr. Taylor?
No question.
Can the witness be released from her subpoena?
Yes.
Can the witness be released? Can the witness be released from her subpoena?
Yes.
Ma'am, you're released from your subpoena. You're free to go.
Thank you.
Thank you. State?
State has no further witnesses. Thank you.
All right. All right. Members of the jury, at this point, both sides have rested their cases. That means that the presentation of evidence, testimony, and exhibits has come to a conclusion. If you remember when I gave you those preliminary instructions when we started, I talked about three things: listening to all of the evidence, hearing the argument of counsel, and listening to the law as I instruct you. At this point, we need to take a break so the attorneys and I can sit down, now that everything is done, and work on those jury instructions to make sure they're in final form, so that I can instruct you on the law, you can hear those closing arguments, and then we'll release you to go and begin your deliberations. That does take some time. So, and of course, after we're done working here, I want to be able to give the attorneys a break as well to get ready for those closing arguments. So my plan is to, did anybody want to be heard before?
Could we?
So what I'm going to do is give you a break. If I could have you back downstairs at the jury assembly room at 12:30, and then we're going to get you rounded up and get you back up here and get going with, if you remember, it's going to be some initial instructions by me on the law. The attorneys will have a chance to give their closing arguments if they wish. Then there'll be some final instructions, and then you'll begin deliberations. So remember, now that everything is done, please remember the rules. Don't discuss the case amongst yourselves until all of those things are done. Don't talk with anyone else about the case. And please don't do any research or watch any coverage about the case. All right, so we'll see you back downstairs at 12:30. Thank you. All right, you all can have a seat. As I was coming downstairs, Kelly handed me an email from the state with, I haven't had a chance to look at it yet.
So you have a printed copy?
I do, I had to print out a copy for me.
These are the ones I emailed last night, just in case.
All right, so
Not for judgment.
I assume that this has all of the changes that we discussed yesterday?
Yes, to the best of our ability, yes.
All right. So let's go ahead and take a run through these. And Ms. Benefield, please feel free to share a copy with your attorney. Look over his shoulder. So, Mr. Taylor, as we go through these, we'll take our time, just look at them. If you have any objections, additions, corrections, deletions, please voice them. State, even though you prepared them from the standards, if you have any objections, additions, corrections, or deletions, please let me know as we go.
Yes, sir, thank you.
All right. First, 3.1, any objection?
No.
3.2, statement of the charge, any objection?
No.
7.1, introduction to homicide, justifiable, and excusable.
No objection. Do have to the second part under great bodily harm. Means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I object to that part. And I think particularly because of the nature of the facts in this case.
State.
It's a standard jury instruction, Judge. We'd be asked that it be read unedited.
Specifically, Your Honor, because of the unique facts of this case, that is to say, relatively minor bruising leading up to the crescendo of the actual event, I think to keep this instruction as it is to the distinct detriment of Miss Benefield, because it's basically telling them that they can overlook what precipitated the final incident.
All right. I understand your argument. It is part of the standard jury instruction. It's not misleading in its nature in describing great bodily harm. It complies with Florida law and the statutes. I think it needs to be given as part of the standard instruction, so I'll overrule that objection. Other than that one, the rest of it looked all right?
Yes.
7.4, murder in the second degree.
And it's the state's position that part in yellow about sudden provocation should come out.
Judge, I'm sorry. I just wanted to also mention, in the May update to the jury instructions, they cut out the reference to mere bruises.
No, well, online, it still has on the.
Do you have the Florida Supreme Court order on that?
I'm on the bar website. So
No, defense. Do you have there'd be a Florida Supreme Court order. Do you have that?
I do not have it with me, no, but I believe that it was removed from the May update.
You have it right there, man.
I may have it, Judge. Give me 1 second.
Yeah, I'm gonna have to see it. The Florida Bar website still does not include mere bruising.
Okay, here, Judge.
Well, can you show it to the state first?
Well, this is a different instruction, sir. This is not homicide. This is justifiable use of deadly force. That's a different instruction. That's the one that was updated in May. Murder, the introduction of homicide was not updated in May.
This is 3.6F, justifiable use or threatened use of deadly force. Court will note that mere bruises has been redacted.
All right, thank you for letting me review that.
Just to make sure we're clear, the old version of self-defense read exactly like the new version. It wasn't taken out in 2024. That was not the parts that were amended. On 3.6.
All right. Again, I appreciate the argument. It's a standard jury instruction. It's not a misstatement of the law. I'm going to give the standard. All right, 7.4.
It's okay.
And Judge, it's the state's position that there's been no evidence of sudden provocation. I'm sorry, heat of passion on adequate provocation. There was no evidence that a reasonable person would have lost normal control, would have been drunk. There was no evidence of a blind and unreasoning fury, so the state would ask that that section be removed.
Do you want the sudden provocation? Towards the bottom of 7.4, going to the second page.
It's the yellow part.
I'm fine with it like it is.
So you want it in?
Yes.
And state you want it out?
Yes, Judge, I don't think there's been any evidence that entered to go to those facts. That portion, pardon me.
All right, I'll leave it in. (3.3D) possession firearm.
Fine.
State.
Feelings.
3.4 lesser included.
Fine.
7.7 manslaughter.
Fine.
3.3A aggravation of manslaughter with a firearm.
Acceptable.
All right, 3.6 justifiable use of force.
Yeah. Which one? Yeah, two small tweaks.
I'm sorry, which instruction are we on?
3.6F.
Oh, okay, that's what I thought.
I wonder if the court would consider under the second part giving an instruction on imminent, what imminent means. The instruction as is reads, the danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real. We could provide to the court a definition of imminent, but we'd like to have it.
All right, do you have it? Do you have a proposed jury instruction?
I'm not prepared at this point to tender it to the court.
Well, this is the final charge conference, so I'm going to need it.
Give me a moment if you're on.
Yes, sir.
Okay, here's one that we have, Judge, in preparation. I'm trying to keep up with all the paperwork. It's the one about. Your Honor, I'd also like to request, if we could, adding a definition of great bodily harm in the deadly force definition paragraph.
Where did that definition come from? Immediate.
I think it might come from case law.
It says it comes from Webster's Dictionary. The state objects. Number one, that definition does not make sense to the state. Number two, I'm on Webster's Dictionary where it says it comes from, and that is not the definition provided by Webster's Dictionary. It's partially, it's parts of the definition, but the Florida Supreme Court has not felt the need to define imminent. I think imminent is a word that is commonly understood by these jurors, and the state would object to adding that definition or changing the definition of great bodily harm in this 3.6, which I think was his second request. which it's in the second paragraph. Great bodily harm means distinguished from slight, trivial, minor, or moderate harm. That second paragraph.
We're not asking the court to change the definition of great bodily harm. We're just asking Your Honor to add it in that paragraph as well.
In which paragraph?
Under 3.6F, the second paragraph, where it defines deadly force, means force likely to cause death or great bodily harm.
The very next sentence is the definition of great bodily harm.
Well, it's got a definition of great bodily harm.
No, it's not.
And actually, my copy has an explanation.
That's the,
Right, it's
that's the standard.
it's from the standard.
Yeah, okay.
And then it was you asked for imminent, you made your arguments against it, rebuttal.
No rebuttal other than I don't see what the downside is to it. I don't see how there could be any prejudice.
Okay. I appreciate that. I've never given a definition for imminent, and I'm not saying my ruling is based upon, well, I've never done it in the past, why would I do it now? I've separately and independently reviewed your proposed definition of imminent. I don't find imminent to be a word not in common usage or understood by an average juror. I don't think it needs to be defined. It's not defined in the standard. So do you want this marked and put in? Because I don't think you read it in, so let me mark it to preserve. So this is defendant's proposed definition of imminent. Is today the 30th? All right, that'll be filed.
And Judge, I think we got ahead of ourselves in this instruction. So if we could go back, under the paragraph on 3.6F, the first page, it says the law and justifiable use of deadly force is as follows. It's the state's opinion that that first section in yellow would come out because of where it says, but is not relying on 776.0131, which this defendant is relying on that portion, which is the very next portion, and is almost identical, other than it adds extra things about since she was in a dwelling.
Well, that's what we discussed late yesterday, so
Yes.
you're in agreement?
Okay.
Yeah.
All right, so
I'm sorry,
that,
Judge, I didn't realize we made a decision on that.
well, I don't think we made a decision. I just rambled on and on explaining the difference between the two and the distinctions and why 776.0122 and 776.0312 differed than 776.0131, but covered the same ground. Just one is general self-defense and stand your ground, and the other one is in your home. And I would think that the defense wants the in your home.
Yes, sir. So I think we would pick up after that law on just to if she's in a dwelling, that portion.
Right.
Okay.
All right, here's where we're going to need to take a few moments to talk about the forcible felonies. And Mr. Taylor, I had written them down yesterday. Hopefully you saw, oh, there it is. All right, state yesterday, well, let me confirm with the defense. So on the actual self-defense instruction that we're going to use for the 776.013 subsection 1, I assume that you're going to want A and B?
Yes.
Okay. And then the forcible felonies you mentioned yesterday are burglary, felony bat, ag assault, false imprisonment.
Correct.
Are there any others?
No, sir.
No felony battery. I thought that felony. Did you say felony battery?
Mm-hmm.
Okay, I'm sorry.
That's what was requested.
Yes, I missed it when you just said it, Judge. Sorry.
Burglary, ag bat, felony bat, ag assault, false imprisonment. State, are there any of those that you want to agree with before I hear argument from both sides?
No, Judge.
You don't agree with any of them?
Well, I may agree with false imprisonment. I need to think through burglary still. I've been thinking through it for the last 12 hours or 16 hours, but I'm not sure yet on that one. So I just think there's problems with each one of them, and I'd rather if we could just go through them.
Okay, burglary.
I think it's a classic remaining inside. The testimony, if the court recalls, from Ms. Benefield was that when he spun her around in her effort to leave the home and block the door, she summoned the wherewithal to command him to leave now. You have to leave now. That would have revoked his license to be present, and as a result, at that point, he was a remaining inside burglar.
All right, well, that's not just the end of it. So I've got the standard instruction for burglary, which would need to be obviously modified because I don't instruct them on the burden of proof. It's just the elements for any of these forcible felonies. The initial portion is going to be the elements of or for the forcible felony of burglary are, and then it'll give the elements. But if you, on the burglary under 2, there's 2A, B, or C, so I need to know which one of those you're arguing. And based upon what you just argued, I'm assuming that you want 2B, as in Bravo, that would be essentially 2 would be Doug Benefield, after entering the structure, remained therein after permission to remain had been withdrawn and with the intent to commit, there has to be some crime alleged, right? Because it can't be burglary or trespass, or it could just be an offense other than burglary or trespass inside the structure. I need to know what you're proposing.
Give me a moment. I think we would prefer other than, Your Honor.
All right, State, now it's, and are you asking for any other portion of the burglary statute if it's to be given?
Give me just a minute, Your Honor. Judge, could I see the instruction the court is referencing?
It's 13.1. 13.1 burglary.
Now, we're having computer problems, Your Honor.
I think the internet just came back. It was down.
Okay.
Right, here we go. All right, what was the court's question?
On the burglary
Yes, sir.
instruction. So we've nailed down the elements that you're asking for. I'm asking, is there any other portion of that, before I go to the state and get their argument, is there any other portion of 13.1 burglary that you're requesting?
Judge, are we talking about, I just want to make sure we're talking about the same thing.
Yeah,
2,
so-
A, B, or C?
The court is giving 1 and 2 had permission or consent to enter, and 2 after entering remain therein.
Yep, and then I have to give A, B, or C
Okay.
as appropriate. And I'm sorry, that's A, B, or C. Can be in the conjunctive or the disjunctive.
All right, we would request B and C, Your Honor.
All right, and on C that you're requesting, is it just to commit or attempt to commit a forcible felony?
Yes.
Which potentially will be. Now, any other portion of that instruction before I go to the state? Or you state, whenever I get over to you, if I do decide to give it, if there's any additional portions, you heard to argue those.
No, that's it, Your Honor.
All right. Okay, that's it, state. So they want, defense is asking for that. Are you looking at the standard for burglary?
Yeah.
So it's on the second page, and if I give it, it'll essentially be something along the lines of, the elements of the forcible felony of burglary are 1, 2, B, and C. On B, of course, the conveyances would be struck. B would be after permission to remain had been withdrawn and with the intent to commit an offense other than burglary or trespass inside the structure. C, of course, there'd be an or. C, commit or attempt to commit a forcible felony. So obviously you object to that, but if I am going to allow it, is there any other part of this instruction that you would want to be given?
Oh. 2 paragraphs, well, let's see. It says the next paragraph is about intent being an operation of the mind, but the following paragraph says, even though the unlawful remaining in a structure is proved, and I know we're not supposed to talk about proof, so I don't know how we would word it, but the evidence does not establish that it was done with the intent to commit a crime other than burglary or trespass, the defendant must not be found guilty. I don't know how we would word that because we don't have proof, but I think that is an important definition.
Good news, I have suggestions.
Okay.
All right, so the state, in addition to what you're requesting for the elements, is asking for those next 2 paragraphs to be given, which explain intent. And I only had, when I say I have suggestions, this comes up in, I don't want to say every self-defense case, but so many of them, I have language that I've used in the past.
Yes, sir.
All right, so here's what I propose it would sound like, and everybody can object, because you don't want it, you want it, but you might not like the language, but I've given it before and it works. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Here's where the changes are, because we're not saying proof beyond a reasonable doubt or anything like that. Here's where I've made changes. Even if an unlawful remaining in a structure is proved, if the evidence does not establish that it was done with the intent to commit an offense other than burglary or trespass, then a burglary has not occurred. That's what I've said in the past. And it's an accurate, I'll let you hear your arguments, but I've found that it's an accurate statement of the law, because the other way is the defendant must be found not guilty. That's not what we're talking about here. So it's just letting them know that what intent is and how that portion of the instruction operates.
Yeah, that's fine with us, Your Honor.
All right. Do you need that, State?
I will need that. And I can say, based on the conversations we have, I don't have an objection to the instructions as you've crafted them.
All right.
I just need to-
Oh, I'm sorry, and we also need structure, because structure is not defined in any of the other instructions, and that's on the very next page. All right, Mr. Taylor, what I've done is I took the standard instruction and have amended it in my own hand as I've read. Do you mind if I give this to the state so they can take it back and make it part of the instructions?
No.
All right, thank
Does
you.
that include the elements portion too?
Yes.
Okay, sorry, I was trying to do it
Yeah.
as you were talking, but I wasn't keeping up.
My penmanship is horrible, I
That's fine.
apologize.
This is perfect, Judge, thank you.
All right, so that's what I've approved for burglary. Let's talk about false imprisonment next. And that's instruction 9.2.
Judge, I had one thing before we leave. on the last portion of 3.6F, justifiable use of deadly force. I wanted to ask the court to substitute 2 words in the final section.
I don't think we've gotten there yet.
We not gotten there yet?
Not to the end of the instruction. We're still doing the forcible felonies portion. Yeah. So the next forcible felony that the defense has requested is false imprisonment. So 9.2, if I give it, again, it'll begin with the elements for the forcible felony of false imprisonment are. So which one of those elements or methods by which one is falsely imprisoned do you think the evidence supports, Mr. Taylor?
We would like to have confined and restrained.
Just those 2, okay. And also on number 1, it would need to read Doug Benefield forcibly, secretly, by threat. Which one of those?
Forcibly.
So you're not asking for secretly or by threat. That actually make it easier because secretly has to be defined.
How about forcibly and by threat, Judge?
Will it be or? And that means we would not need secretly. All right, State.
The state would object. There is no evidence of the time in which Ms. Benefield used deadly force that Mr. Benefield was preventing her from leaving. If there was a time in which there could be argued a false imprisonment, it would have been when she tried to get out the door and claims that he spun her around by her arm. But there was no evidence that when she was in the bedroom, there was any effort to forcibly or by threat confine or restrain her without her lawful consent, so the state would object.
All right, rebuttal.
Well, actually, I believe the testimony was that when she turned around, he was standing in the middle of the doorway, blocking the exit to the room.
All right, I understand completely that each side has their own theories and thoughts and not versions of the facts, but view of the facts. However, the facts as presented by the defendant do support the giving of this instruction. False imprisonment, here's how it'll read. The elements for the forcible felony of false imprisonment are Doug Benefield forcibly or by threat confined or restrained Ashley Benefield against her will. Doug Benefield had no lawful authority to do so. That would be the end of that instruction. As I review the rest of it, the rest has to do with certain enhancements.
Are you giving me that one too? Are you going to give me that one too?
I would ask.
If not, I'm going to need you to repeat it.
Yeah, no. My plan is to, after I do this, give them to you because then it's all, I'm sorry to put that on you because I know you're objecting to it, but.
On her.
All right. Anything else on false imprisonment? So I am going to give it as I just read.
Yes, we would request a specific definition of the term false imprisonment based on the case law Broco versus State, if I may.
A definition of false imprisonment?
Yes.
The elements are there.
Isn't that the elements of false imprisonment is the definition of it?
This just lays it out, Your Honor.
Okay. Let me just, go ahead and take a look at it real quick, State. Thank you. All right, did you want to be heard on this?
We object. I think the elements are sufficient.
Any further argument?
No, sir.
All right. I see where you pulled case law that defines and explains some of the factual scenarios that have been presented in various cases and whether those meant or equated to or violated the false imprisonment statute. But I don't think I would give a definition of false imprisonment in the false imprisonment instruction. It's false imprisonment, then you explain the elements, and then both sides can certainly argue whether those acts were or were not violative of false imprisonment. Do you want this one, Mark?
Please.
So let me do this. Same thing, it's just my marked up version that I'm gonna give them so they can,
Yep.
that way the typeface will all be the same. Thank you. For
Thank you.
instruction in false. Where to put this? There we go. How about aggravated battery next? I'm trying to take them in some semblance of descending order. Might not be perfect, but all right, ag bat. So I guess what I'm looking for defense from you is what parts or portions of aggravated battery 8.4 you're asking for. It would start with Doug Benefield, A or B under number 1.
Judge, I think, frankly, after reviewing this instruction, we're going to withdraw the request.
Okay. So ag bat is withdrawn. Next one is felony battery, 8.5.
Yeah, we're going to withdraw that as well, Your Honor.
All right, felony battery is withdrawn as a forcible felony. And the final one that you had requested was 8.2 aggravated assault.
Requesting to be. Sir.
While there's a brief break, everybody check your phones, make sure they're on silent or
Okay.
turned off.
This
please.
one, I think, is viable.
You want to keep?
Yes, sir.
All right, and so let's look. There are some options, so let me go through them. So 1 is standard, 2 is standard, 3 is standard, but then under 4, are you asking for A or B?
B.
And what is the felony charge? The assault was made with a fully formed conscious intent to commit.
I think false imprisonment, Your Honor. Give me just a moment. I'm considering whether it would also establish any of the others. False imprisonment, Your Honor.
Sir?
False imprisonment.
Okay. State.
It's the same argument. Well, it's a two-part argument, Judge. It's the same argument as to false imprisonment. I know you already were getting it, they're getting it, but I don't think that there's evidence that he made threats by word or act, I guess, other than "you're done," which the state would argue is ambiguous. At the time, the defendant Mr. Benefield appeared to have carried out the threat. I don't know what that means for this case, and the defendant created a well-founded fear of violence was about to take place. I mean, I think this is so akin to the self-defense argument that I think it's duplicative, but also to then say the assault was made with a fully formed conscious intent to commit false imprisonment against her. Their argument was just that he was already false imprisoning her when I just don't know how you would put this in there, Judge, because he was already committing a false imprisonment, and then when he made the threat, he was then fully informed to commit another false imprisonment. I just think it's circular, and I'm not sure that it will make sense for the jury. I think it'll be confusing.
Like most of these things, it becomes a question of fact for the jury, and I'm not prepared to say precisely when, given those facts and the fluidness of the circumstances, when, or for that matter, if the jury will conclude that there was a false imprisonment.
All right, thank you both very much. I'll give it. The question is, any other portions of that, or it's just the elements of that one? Certainly, there's no deadly weapon.
I think the first one, if the circumstances were such, that should be in. Deadly weapon is out, as would be an object not designed to inflict bodily harm. Great bodily harm is out. As would be, Judge, not necessary that the defendant had an intent to kill.
Okay, you give this one to the state, so that'll be the last one. So we ended up with 2, right? 3.
And I guess, Judge, I'm gonna need some guidance on how to word this. Imminent commission of forcible, or burglary, comma, false imprisonment, like, that sentence isn't gonna make sense.
I'll give that to you.
Thank you.
All right, so I think it would need to say imminent death or great bodily harm to herself, or the imminent commission of burglary, false imprisonment, or aggravated assault against herself. It'd be in the disjunctive, and then immediately after that, I'll need
Those in order.
yes,
Yeah.
thank you. All right, the next portion of what we need to discuss on the self-defense, we're still on 3.6F. We're through the use of force in the home. The very next paragraph talks about 782.02. This is the bottom of the second page of the state's. I think it's on the bottom of the second page.
I thought I took it out.
I think we talked about yesterday removing that, but let me make sure. The portion about 782.02.
I think I already took it out, though.
I thought we did, but I have a question mark next to the one on my copy.
Oh, okay.
So I'm just making sure.
I have the next, just for clear, the next paragraph I have after the ones we were just discussing is in deciding whether Ashley Benefield was justified, is the next paragraph I have on the one we did last night. Is that what you showed, Judge?
I look at the wrong.
I had thought you had asked yesterday if we wanted A and B, and we said yes.
That's not what we're talking about.
On which one? I'm talking about the portion that was 782.02. And like the state said, I have it, we weren't gonna give it, but then I have a question mark by it, so that makes me wonder if it was, we're not gonna give it, but we're gonna think about it.
Yeah, I marked it out. I had it. I could.
Again, I think that's what it is, but this could be just me having a question mark there for, I don't know why. But I just want to get confirmation on the record that we're not giving it.
Yeah, we'd like to have it, Judge, and we would request B and C.
All right, any further argument?
No, Your Honor.
No.
In response to the court's question, did I have any further argument?
Okay. So before I go to the state, because this is my question, if we're giving 776013 that talks about the approved or justified use of deadly force when one is in their own home or in their own residence or dwelling house, including, and I'm going to give to prevent the imminent death or great bodily harm to herself, the imminent commission of those forcible felonies that I'm allowing, what are we gaining by adding 782.02? It seems duplicative to me.
Be the first time that there's an instruction that overlaps.
All right. State, you want to be heard?
Yes, Judge. It's not an instruction that overlaps. It's repeating parts that are already in the instructions. The first paragraph is in 7.1, justifiable homicide, that almost the exact paragraph. And I believe the state's contention would be these are cases that are not when there's been a homicide, so you wouldn't have read 7.1. That's why it would be in self-defense when you use deadly force, but it's not necessarily a homicide. And I think that to say B and C, that is exactly what you've already just read. And I do think it's duplicative, and I think could be confusing, and we'd object.
All right, final thoughts.
Nothing further.
I think I've shown that I tend to give instructions when they're lawful, they're an accurate statement of the law. The facts of the case support the giving of the instruction, and it's necessary to explain or clarify an area of the law to the jury so that they can do their job. However, when you look at what's being proposed under 782.02, that portion of the instruction, it is, while a different order, it's virtually identical. Subsection C talks about the commission of a felony upon Ashley Benefield in a dwelling house in which she was present, and that is taken care of in the instruction we're giving from 7760131. It starts, if Ashley Benefield was in a dwelling or residence in which she had a right to be, and then she's justified to use that deadly force to prevent the imminent commission of a forcible felony. So C is taken care of in what we're already given, and so is B, because it talks about committing a felony upon her, but doesn't talk about the dwelling house. So quite frankly, we're already giving that. That wouldn't just be duplicative, it would be the exact same instruction being given twice. The 776.013 subsection 1 covers all of the issues and elements that have been presented. All right, the next one is then in deciding whether Ashley Benefield was justified. Certainly that's in. And then we discussed yesterday, all of that middle part is out. And then the last portion.
Yeah, Judge.
Yes.
They've added, if I'm not mistaken, they've added totality of circumstances to that paragraph.
Which paragraph?
In deciding whether Ashley Benefield was justified in the use of deadly force, you must consider the totality of the circumstances.
It says you must consider the circumstances at the time the force was
they've
used.
struck by which he or she was surrounded. So totality of circumstances at the time.
All right, do you have that where it was?
Yep. Page 4.
If you just show that to the state first.
Those are proposed, that is not what happened. It's online is what happened. Those are proposals. We didn't strike it. If you look at 3.6 as the Florida Bar has it, it's the same. That's a proposal to the subcommittee.
So we would like the proposed language.
Okay. Oh, so is that just a memo that you wrote?
It's the commission, it was when they proposed instructions before
Yeah,
they
this was from the committee.
So the committee proposed putting in totality of the circumstances, but it wasn't adopted?
Correct.
Okay, I got you.
We would object.
As the board
Object.
knows, it's not married to the patterns any longer.
All right, thank you very much for the argument. I think the standard jury instruction that we're dealing with adequately explains the law. It's not a misstatement. It's not going to mislead the jury in any way, so I'm not going to add totality of the circumstances. The jury is told you must consider the circumstances at the time the force was used, so I think it's sufficient. So that remains. And then if you look, then all that middle part is out, and then it goes to if you find that Ashley Benefield, who because of prior threats or difficulties, had reasonable grounds to believe. Do you see that part?
Actually, I already took it out on the version I did last night, Judge, so it might be, I think he's working off the state's newer version. I took out everything you had already said.
Right, all that middle part is out, so it's going to go from, you must, look at the circumstances that she was faced with, and then it has the part about, you may consider and you should consider those prior threats and acts of violence that she knew about or was aware of.
Mm-hmm. And so now I had on the penultimate paragraph,
Yes, sir?
rather than committed an act of violence, we would request that it read, had committed acts of violence. You may consider rather than that, this. Based on the evidence, there's obviously more than one act.
All right.
Where exactly?
Okay, right.
As you said, the penultimate paragraph, the next to last paragraph, and it says Doug Benefield had committed an act of violence. They want it to be acts of violence.
Oh, it does say or acts of violence on the standard, so we have no objection. I'll change it.
All right, well, so do you want it to say an act or acts, or just committed acts?
Acts, A-C-T-S, acts of violence, and you may consider this rather than that.
It's that fact in determining.
You wanted to say this fact instead of that fact?
Correct.
Okay, I don't know.
Plural as opposed to singular.
Sure.
That's fine, Judge.
All right, anything else on 3.6F?
No.
State?
No.
Okay.
Thank you.
3.7, any objection? It's got to sound horrible. Sarah, you're not writing down each sniffleite, are you?
No sniffles.
Okay, thank you.
It's a lot. You have to make a new button.
So if they let that happen. Judge, I think there's a sentence missing on this one. Proof beyond a reasonable doubt does not mean proof beyond all doubt.
Where is that at?
It would come right before a reasonable doubt is not a mere possible doubt. I'm looking at the 3.7.
Which paragraph are you on? I'm sorry. Oh, okay. I found it. Oh, that's an update since 2024. There is an update.
Is that the only update?
Yes, that's the only request that I have as to that instruction.
Well, looking at that one, they've also added, is this one of the ones that just came out in May or July? So if you look at the standard, are you on the Florida Supreme Court website? Is that what you guys are looking at too? It also has an addition. See, right in about a third of the way down, the defendant is not required to present evidence or prove anything, which is what we've always had,
Right.
except for the defense of affirmative defense to the crime of relevant crime, as I previously explained to you.
I think that would apply in this case.
Do you want to make an argument for or against defense?
Judge, would you mind if I printed while you're talking so that I can correct it for her?
Of course.
Okay. I just didn't want to be rude.
Yeah.
Yeah, so, it's interesting, Judge, because self-defense is an affirmative defense, but yet in the instruction, they don't acknowledge that. They just limit the instruction, or as a suggestion, insanity, reunification of an attempt, or rather renunciation of an attempt. No, I think that's confusing. I wouldn't request that.
This is interesting. I'm not even aware of any case law interpreting this edition yet. Because it's interesting, and State, I'm just going to throw this out there. So certainly, it's an accurate statement of the law. I think we can all agree on that, right? State has to prove beyond well, first it's a prima facie case, but proof beyond a reasonable doubt. Then there's the preponderance of the evidence that an affirmative defense, and the defendant has the burden of production and persuasion on it, but then the burden shifts back for the state to prove beyond a reasonable doubt the defendant did not act in. So it's interesting because this addition says they're not required, defendant not required to present evidence or prove anything except for the defense of, but then doesn't talk about that burden shift. I don't know. I wasn't on the committee. I'm on a different committee, so I don't know how I understand explaining, well, the defendant does have some burden, but then not telling them that it's a preponderance of the evidence, more likely than not, greater weight of the evidence, whatever words they wanted to use, but then the burden shifts back to the state to prove beyond a reasonable doubt the defendant's not entitled. So, do you want to be heard?
Yes, I think that we're asking for it. I think insanity and renunciation of attempt are examples. It says e.g. So I think it's well established that self-defense is an affirmative defense, and I don't know what legally would prevent it from being included in this instruction. And I think it is, as Your Honor has already said, an accurate statement of law. So we are asking for that paragraph to be included.
Not that this isn't difficult enough, but if the court does decide to add that, I think the court, in fairness, would be required to elaborate on the burden shifting back to the state, as the court just acknowledged.
All right. Thank you both very much. And certainly, whenever after I read the instructions and I charge the jury, I'll obviously ask if you have any objections to how the jury was charged. If it's just all the same previous objections, just renew your objections. Here's the reason I hesitate to give this right now. It's brand new, and I could be wrong, but I do have some concerns about how truncated it is with the actual nuances of the burden shifting that goes along with affirmative defenses and not explaining that. So I would feel some compunction if I were going to give this new portion of this instruction to explain that. At the end of the day, though, and remember, where am I getting to? So I could take that path with this new instruction, but going this way with just giving the instruction how it's always been, at the end of the day, the jury still has to find that the state has proven beyond a reasonable doubt the defendant's guilt and proven beyond a reasonable doubt the defendant is not entitled to. So I appreciate everybody's arguments. I could be wrong, and I'll let somebody else get the case law and how this instruction is going to work now. So I'm going to leave it at the defendant is not required to present evidence or prove anything. You added in that additional sentence, proof beyond a reasonable doubt does not mean beyond all doubt.
Oh, I'm sorry, Judge, so you're gonna put a period after the defendant is not required to present evidence, or you're just putting a period there and leaving the rest out?
Yes, leave the standard that is the standard in my mind.
Yes, sir.
And then you added in that sentence at the beginning of the,
I printed out a new one for her,
perfect.
yes.
Any other changes?
No, sir.
State, 3.7 good?
No, nothing else.
Except for the objections about?
Yes.
Yeah. That'll be interesting to see how that plays out. All right, 3.9.
No objection.
All right, perfect. Again, that's where I'm going to stop and then explain to the jury the verdict form. Any objection to 3.10?
No.
3.11?
No.
3.12?
No.
3.13?
No.
During that same paragraph, I talked. I'm so sorry. That same paragraph about during the trial, items were received, they'll be sent back. I do ad lib at that point because we have a tech card that's right out here in the hallway. And when they go back to deliberate, they can play is it just the 911 call? Is that the only thing that's in?
Well, there is a DVD of text messages,
If they want to do it,
if they
All
want
right.
to read
They
them.
have a computer back there that has no access to the internet. It's just a laptop that is on the tech cart that they can use to view items or listen to items. So I do go off script there to tell them that. Also, up a couple of paragraphs from there when I talk about the cell phones have to be and electronic devices have to be left out. I also talk about smartwatches that can independently and separately communicate with the internet outside of Bluetoothing with another device, and that they have to leave their smartwatches with the deputy. All right, and then the verdict form.
No objection.
On the manslaughter, I thought the manslaughter was just,
We were just talking about that.
yeah, I think the manslaughter might need to be,
Sometimes
it's just one question, right?
Well, yeah. You mean breaking the questions up? I think
Right.
this is the jury instruction we've been using because I think that it is confusing I think it puts too much emphasis on the separate charges if you break them up. And I think if they checked manslaughter and then 1, 2, and 3, there's no harm. We just ignore 2 and 3.
All right. Do you want to be heard on that? Because the factual findings are different between, obviously, the second-degree murder and the manslaughter for the sentencing enhancements and the 10-20 life.
I don't have a problem.
You're okay with this one? All right, there we go. It's not a problem if nobody objects. Well, if there's nothing else, then I'm going to let you all go. It's right about 10:30, so that'll give you 2 full hours. If you could, though, be back, maybe 12:25, 12:20, 12:25, so we can get the courtroom all set. Everybody can be ready to go. I can get the jury up here, and we can get started.
Is there going to be a long J-way argument? And if so, when do we want to do
Oh,
that?
did you want to make one now, or do you want to wait until after we let the jury go?
After you let the jury go.
All right. So the reserve on that. All right, y'all. We'll see you back in a little bit.
Thank you.
Okay.
More continuing coverage is on the way. The Black Swan Murder Trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.